Okay, so welcoming back everyone who was here yesterday, and an additional welcome to people who've just arrived for today's events. For those of you who were here yesterday afternoon, you'll be thrilled to see that in our new building we have acquired a 21st century solution to the heating yesterday, which is we've jammed open the fire escape door. And we're going to leave the back door open. So thank you. Don't close it. So I apologise for the heat yesterday afternoon. This is the first big conference that we've had in the building, and we're still managing the snags. For those of you who weren't here yesterday, just to say that we had a fascinating day yesterday. We heard about UK and overseas developments. Everyone's so excited. We heard about UK and overseas developments in terms of ranging from digitising existing processes to massive system redesigns. And it confirmed that the developments in train are going to lead to major changes in justice system, in the way that justice systems operate. There's going to be less physical congregation. There's going to be more online dispute resolution. There are going to be more asynchronous processes, and there's inevitably going to be less in the way of adjudication. I think this raises a lot of fascinating questions for state justice systems, and in particular, one of the things that came out yesterday, and which I hope that we're going to pick up on today, is what are the features and values that we need to preserve? What are the features and values, if any, of our current justice system that we need to preserve as we redesign our processes? Interestingly, one of the things that struck me is, are we essentially crowdsourcing a new justice system, which is something that we might want to think about, and questions like what happens to the law in the new system. I think these are questions that arise from the developments that we discussed yesterday. Also, issues that arose were how we think about outcomes and substantive justice and the concept of rectitude of decision when we're looking at the kind of system that we heard about in Canada. And ultimately, how do these systems meet rule of law principles? Today we're going to be picking up on some of those things, but in particular, the panel, you can see the titles of the panels, are focusing on questions of openness, open justice, open and transparent justice system, what these changes mean or are likely to mean in relation to public expectations of justice system, their experience and expectations, and what that means for trust and confidence in state justice systems. And very importantly, something that I'm interested in is what this means for the judiciary. How are the judiciary going to adapt to the new online world in which they essentially become cyber judges? How do we train them for that, and how will they meet that challenge? So those are the things we're going to be discussing today. Just something that I didn't mention yesterday, but which I will mention today, is, well, I will repeat the fact that we are being filmed today. We will be setting up a conference. After the end of the conference, we will set up a conference website. And on the conference website, we will put up the videos of the video of the proceedings. We'll also make available the presentations. I think all panel presenters have given us permission to put up their presentations, to put up the slides. So you'll be able to have access to the slides. And Jo Harwood in the corner there has been diligently taking a note of all of the presentations and the discussion, and she will produce a report for the Legal Education Foundation and the Nuffield Foundation, and that will also go on the website. So you can kind of relax and just listen and know that the material will be available in due course. So without any further ado, I want to introduce our first panel. We've got Judith Resnik, Antoine Garapon, Joshua Rozenberg, and Karen Broadhurst. So it's quite a packed panel. I said yesterday, for those of you who weren't here, that we're going to have vicious chairing, kind but vicious chairing, in order to keep to time, because we want to hear what all the presenters have to say, but we also want to encourage discussion from the floor. So without further ado, I'm going to hand over to Judith Resnik, who is well known as a world-leading thought leader in the area of courts and adjudication.
Okay, so hi. Thank you. And thank you actually for a really totally interesting crash course in thinking through in a multi-jurisdictional way the future is now and the challenges we've got. So most of the discussion yesterday was focused on the concept of access, and access was defined as the individuals who would, as individuals, would either be potential disputants or detoured from being disputants. I want to bring into focus a different kind of access and a different kind of user, which is basically all of us, in a system in which we're looking at how states are or are not involved in issues of dispute resolution. And since we're here, in Bentham House, and since we all owe much to Jeremy Bentham, I wanted to start by, of course, it had already been invoked by Lord Ryder yesterday. The Benthamite claimed that publicity is the very soul of justice. It keeps the judge himself or herself now while trying under trial. So Bentham had claims for the utilities of publicity, which were, one, schools that would be interactive, we would learn. Second, the idea of accuracy, it would ferret out mendacity was his term, and discipline, of course, that the judge and the state of whom the judge is a representative is under the public scrutiny. And so Bentham should be understood at the cutting edge of what today we'd call alternative dispute resolution. He wanted to have judges, we heard that British Columbia is 24/7. Bentham wanted 24/7 judging available. He wanted to lower the costs. He had an equal justice fund. He was inventive in many, many ways. And the reason I entitled this From Jeremy Bentham to Me Too, which is in the United States and in Europe, the Me Too, hashtag Me Too, are groups of mostly women who are arguing that publicity is education, accuracy, discipline, by bringing to the fore claims of sexual misconduct in a variety of different workplaces. So Bentham is not antique in any sense, in that his concerns are not only alive and well, but driving a fair amount of activity. In the United States, has had quite a remarkable imprint, as I will talk a little bit later. We, unlike Europe, have both mandated arbitration systems that are preclusive, not a path to courts, but a path, a barrier to using courts. And nonetheless, the attorney generals of all 50 states, which means whatever, red, white, blue, whatever their political affiliation, they've all signed on Me Too, that you shouldn't be able to mandate closed, private arbitration for sexual harassment claims. This is the political movement with some legs, if you'll say so. And so Bentham is therefore part of our contemporary discourse and our politics. Now, of course, Bentham, like the rest of us, are embedded. So this comes from 1677. I'm still on this side of the Atlantic mostly, and it talks about the laws for the West New Jersey, a colony then, would be to say that every person, any person may freely come and enter. This, of course, tradition which relates to the jury trials of the common law system is this idea of the public performance dating from the Renaissance to legitimate the authority and power, to make the power and authority of the state, and to legitimate it, entailed this kind of public political activity along the way. And now when I come to the United States, here are early constitutions from Connecticut and Alabama. And what's their ad? It's all courts shall be open, remedy by due course of law, obviously echoing the Magna Carta. What we're looking at here is, and I was struck, we were talking before at breakfast, about what's on the websites from British Columbia or your websites here. Does it say, come to court, all courts shall be open, we're giving you remedies, the state will provide you with justice? Is that your branding and your logo? Here's what it was that was the effort to portray what government was supposed to claim it was trying to do for you at that time. I would, in legal terms, I would call this a doctrinal openness, an actual right for me to be able to walk into the door of a courtroom now through security barriers, but it's unself-conscious, and part of it's unself-conscious because, of course, Antoine is here with the idea of the physical embodiments of it. We're looking at courts as physical spaces, as community and the like. And I put up this adorable, if you will, quaint Connecticut courthouse still in operation, because of course the question is it obsolete? And how should we think about what to make of this building now? How do we think about both Bentham's claims for courts as platforms for the dissemination of information, and how do we think about their functions in the contemporary world? Bentham was in many ways however critical he was. Judges and company, he hated the common law, coined the word codification, was remarkable in a variety of ways. We can look back and think of him as cheerful because he imagined the tribunal of public opinion, not in a postmodern, critical, multi-factored, different perspective way, but thought that there could be a unified public, and that unified public would therefore come to exert its disciplinary, not a multiple. He also didn't think about a predatory public very much. He did have some concerns around privacy and explain when proceedings could be closed, but he doesn't. Jeremy Bentham is both the beginning of this theories, not one of the many theorists in his era. Kant comes in as well on the roles of publicity, but he's also actually the great-grandfather of propaganda and public relations, who also understood the world of information. And even they, looking back in our current world, look sort of sweet when we think about the degree to which we are living with a predatory public, a hacking public, a disinformation public relations machine. So publicity, which seems so wonderfully positive, is, as we also know, incredibly able to be manipulated, and some of us live in countries whose elections have been profoundly affected by the insights that publicity has produced that have been able to alter. So the image of this courthouse as the font of publicity is both imagining a potentially pastoral time, but before we get too nostalgic, it also was an extremely exclusionary time. So for this is just in the Works Projects Administration, when the U.S. was in a Great Depression, the federal government, U.S. federal government funded buildings, architecture, and art. And in sits this woman who is supposed to be the virtue justice, red, white, and blue, the artist said, just borrowing the U.S. flag to show protector and avenger, to be behind a wall and a judge was to sit in front of her. In walks a reporter in Aiken, South Carolina, where she's to sit, and she's described as mulatto, which is to say dark-skinned, and the trial judge says, get her the hell out of my courthouse, because this image could not represent the virtue justice in the 1930s in the United States. And if I can go back, there it is. She was covered in drapes. She was covered in drapes because she, like the world she inhabited, was in no way welcoming to many people of many colors and genders. And so before we imagine the wonderful world of the past, we have to realize that it was an enormously exclusionary world, and every person entitled to all rights and remedies wasn't all of us at the time. But, and now I've given you a snippet from the amendment to a Delaware Constitution from 1999 that changes the text to say him or her, to say we're all there. And then, of course, now that we're in a transgender world, we might say, whoops, you got to fix those pronouns too. But here we are trying to say we're embracing the idea of all rights to remedies. Basically, what you would see is a big bar chart. And what you'd see on that bar chart is the numbers of filings, that once he, she, and all the various peoples come into the potential for being participants in courts, the volume changes. And one of the drivers of this conversation, because one of the things I'm interested in is what is the political economy that is bringing us here to have this conversation. And what we heard much yesterday was volume. There are too many people waiting in too long queues. Some of them can't get in because they can't understand, and that is driving where we are. And therefore, in the United States, you got some data from British Columbia, and you got some data from here on the volume, and the U.S., which can offer you more data. So what I've put on the screen, because from abroad and in the United States, federal courts are high visibility, but you will see that actually they're the tiniest little bar that you can barely see, because there are about 350,000 civil and criminal filings the whole year, every year. Bankruptcy, which is actually higher in 2010 than it is now, is at best $1 million, and that's also our federal jurisdiction. All the action is in the state courts, and there you have 47 million, and that 47 million cases takes out family, traffic, and other issues. So we're at the 100 million. And the point, of course, of these tall bars is to make the volume question. So now that all of us can be here, what is it that we're going to do? And one answer, of course, is to build bigger courtroom. This is the tallest federal courthouse we've got. And it's 29 stories. Whoops, we just went one too fast. It's 29 stories, and you all can be the judges of its architectural aesthetics. The point is we can add more material spaces in which people could come together. In order to do that, we're looking at general funding. How do we get revenue? Taxpayer dollars, and in the U.S. federal system, we can print the money. On the state side, they can't print the money. So fines and fees are the huge issue in the United States about funding the system. And I put a book out there that anybody can have a copy of, and we can send you more, called Who Pays the Cost of Courts? Because if you scratch the chief judge of any state court system in the United States, they'll say to you, how are we going to fund our system? We have users who can't afford it. We have unrepresented. A quarter of the filings in the federal civil system come with no lawyers. About 80%, depending on the kind of case in state court, is like here, with people who are not represented. And what you're looking at here is we can't even figure out how much people are charged. So there's a task force in Illinois that tried to figure out how much it would cost for what, and you get surcharges for all special things: a family waiting room, a drug court, an ankle monitor if you're in the criminal system, fines, fees. You just got convicted in Michigan, it's $1,600, please pay us. So you're looking at a vast array of costs, civil and criminal, and now actually litigation around the United States, raising questions about the constitutionality and the lawfulness of some of the fines and fee system. And any of you with interest, I can go on about that. So one is build more, pay more, and if you're going to pay, either do it A, through general revenue, or B, through user pays in the public side of the system. Another, as we've been hearing, is to change your process. This is a screenshot from we heard the British Columbia has maybe a better looking website. This is the US website. Notice it is trying to brand itself with an eagle, which is our predatory symbol of our favorite bird. But if you go inside to see it, what does it say? What did it say? Welcome to the federal courts. My shorthand, please go away. But it's actually not so different from your shorthand that we saw in British Columbia and that we might see here, which instead of saying, come to the federal courts, all rights shall have remedies, it says, couldn't you please find an alternative system through which to get your remedies, which is try, in this instance, I'm showing you about alternative dispute resolution inside the courts, which is to say, can you please resolve your dispute without using adjudication? So we're watching courts advertise, be their brand, be please don't use us. And this is multi-jurisdictional, and it's judges and administrators at the front end of conveying a message that the central function is to not use the system that it has and to try something else. It isn't the only way to have this discussion. It could be, we'd love to have you if you'd like, and here's another door, and here's another door, and here's another, but that's not the message that's currently being used on most of our screens. This isn't a U.S. story. And of course, also not a U.S. story, there are declining rates of trial in the federal civil system. Of 100 civil cases filed, 1 will start a trial. And on the state side, in addition, there's also actually declining filing rates. And if you disaggregate by kind of case, radically declining filing rates in a whole host of instances, which we also heard about here and I know in other jurisdictions. So, says a federal judge, we're an endangered species. How will you show us? Behind this computer, not in front of the public, trying to negotiate and on phone calls and on screens with people. And he says it with some concern, and this is what I would call as functional privatization. So at the formal level, we have doctrinal openness, all of those statutes and rules about open and public. And then in practice, you can't watch anything and you can't see anything if we're doing it in chambers. You might do it in open court, but you might be in the US at least in chambers. So we're the public role. Now, this is a pictograph that we'll have to get permission for your website to use from Hill, which is a Hague-based NGO seeking to help justice systems around the world. And it's the title of the monograph from 2016 is ODR, Online Dispute Resolution and the Courts, the Promise of 100% Access to Justice, ? And of course what it's promoting is the centerpiece of our discussion from yesterday, which is the answer to the problem is ODR, Online Dispute Resolution, which will get everyone in. And this pictograph, as you can see, has either individuals, negotiation, computers, and unlike our judge who was worried about, you'll just show me behind a computer, this is the celebration, watch, look at me, behind a computer. But what you should notice is that there isn't any place in this pictograph for any of us who are not litigants, would-be litigants, disputants, or the potential third party. We're invisible on this screen. There is no all public courts, all shall be open, any person may freely come, because it's not built in. Now I know British Columbia and there's efforts to try to build in some of it on the virtual, but it isn't there at the moment. So this is, we've just done court-based, finance fund, add more judges, change the process, move to online, and we've watched the public sector. I just want to bring you to the private sector for a moment, and I'm going to do this through the United States, which had, influenced by Europe in 1925, an Arbitration Act which has a text that says that we will enforce arbitration agreements that for the first 50, 60, 70 years of its life was interpreted to mean we're only going to enforce them if the bargaining is okay between equal parties, because we're worried that arbitration is too flexible, it's not law-bound enough. And so in the 1950s, when a broker tries to enforce this against a consumer, the answer is sorry, says the US Supreme Court, we won't enforce these because it wasn't even-handed. And we are worried. And I know this remains mostly the law in Europe and in the we'll call Europe UK for the moment, and we'll see where we are in 6 months. But what I'm showing you here, Waffle House is a fast food. This is an actual exhibit in a court, in the US Supreme Court. And what it says is, when you sign to apply for a job here, waive all your rights to go to court. You must arbitrate. We split the costs. We'll also make you take a polygraph if we think that you've eaten the waffles. That's in bigger print than is the must go to court. And the next example comes from my cell phone, and it says, not only must you, it's a terrible graphic because you can't read it. It's a perfect graphic because there's no point in reading it. Because when I went to call to negotiate it, I was told it's non-negotiable. And it's not negotiable. What it tells me is I can't be part of any collective redress. And we haven't talked enough about the questions of collectivity and class actions in the US, but collective redress, the mandate from the Parliament and the Commission of EU for consumer goods, which UK will want, whatever it calls itself, will be questions of where's collective redress in the ODR system. So this bans me from being part of any form of collective redress for my wireless service. Now, a bunch of state courts said, and in this next slide we'll show you, like California, you can't do that, because what it would do would be to take out the party that you're accusing of having consumer defrauded you will be able to control who can bring what kinds of claims. But the US Supreme Court in the 2011 said, I'm sorry, Congress in 1925 thought that arbitration was fabulous. And although we hadn't developed our class action, Congress really meant it should be bilateral, and that means that that these clauses are enforceable as a matter of federal law, whatever states may seek. Now, there are two ideas that animate this, and it's relevant, although you have mediation, and there's some discussion of whether there'll be mandatory ADR or not. In the discussions that are being had, This is mandatory in the sense that if I want a cell phone or if I want to purchase goods and services, this comes with it and I can't negotiate it. The argument is, twofold. One is autonomy and consent. So this is what I pulled off the web from a wireless agreement. Can I change? According to my wireless service provider, it may change any terms, conditions, rates, fees, expenses, or charges at any point in time. This is why I do not call them a contract and I do not call them agreement. They are neither bargainable nor bargained. They are not a contract. They are, as Art Leff, a wonderful law professor in the United States, called it, a thing. And therefore, to think about it as consent is to misunderstand. It's not consent. So the other argument, which has really laced our conversation over the last day, is it's great to do this because it empowers. ODR is going to, online dispute resolution is going to empower, alternative dispute resolution. It's empowering individuals. And this you're hearing from the U.S. Chamber of Commerce lawyer who succeeded, the U.S. Chamber of Commerce succeeded in blocking U.S. federal regulation that would have limited the reach of these to some extent in some consumer markets. And so it's about empowerment. So it's an access claim that repeat players are making as they provide these mandates. And in the access claim, the question I then asked, now to the empirical point, is okay, how many people use it? And because some states in the United States require providers of arbitration services to database their consumer use, and because I have the luxury of astonishing students who are my colleagues at the Yale Law School, we were able to mine databases, and with those databases we were able to look, and because AT&T was the Supreme Court case that took it out, I went to try to find out how much do customers of AT&T use the mandated arbitration system. Between 2009 and 2017, AT&T had between 85 and 147 million customers, and fewer than 60 a year went individually to use the empowering, accessible system that it was proffering. And the Consumer Financial Protection Bureau looked at some credit card markets and basically found the same thing, which is individual use of this is very challenging. That taking out collectivity is key because it's through the collective actions, not only in terms of the costs and the energy, but the knowledge to figure out to read your phone bill, let alone to see that there are phantom charges or some other ways in which, or to know that the Federal Trade Commission has some limits or some others. This is the reason for collective action, is to enable and to respond to the problems of individual, that are presented for individuals to deal with harms that are numerous in their application and impact. And of course, one answer would be that the wireless companies are completely law-abiding, so there's no reason to bring any claims. But the same era, the federal government and state governments were bringing claims about false advertising and the like. So let me get you moving closely toward the end. Collective redress in Europe, which is being promoted by the European Parliament and the Council as a response for consumer problems, as well as online and as well as alternative dispute resolution. And this is their 2018 call for it. And this is getting me back to the political economy and the interactions. So one answer is for governments to say, we want to create services people can use and we need collective actions as well as other mechanisms in which to do it. The comeback that you'll see is, this is a report from the U.S. Chamber of Commerce's Institute for Legal Reform, trying to tell Europeans not to do it, with, of course, waving the U.S. flag. Horrible class actions in the U.S. Really don't be sure you don't import them here. This is a longer conversation. We can talk about this if of interest, but debate, of course, there are concerns about control and monitoring and regulation of group-based litigation, the same as there is of individuals. That isn't to say that there should be none of them. So let me get toward the conclusion. So step one, back to the buildings that many of us have written about in this room, Linda, Antoine, and others. This is the interior of a big federal courthouse designed by Harry Cobb, gorgeous in Boston. Please come visit. And what you'll see there, I've shown you a shot of the courtroom, and look at the space for people to watch. So this is a model that is imagining that there will be lots of people. It's actually designed with 4, we're all equal, so the arches are there for us all to have all equal parts. And if I try to bring it to your country, Lord Reed invoked yesterday in the Unison opinion, it's saying that through cases, ordinary people's names stand for principles, and the law is known, and the law is developed, and there's public precedential decision-making, but it's also an understanding that the government is providing for you goods and services of dispute resolution. So one model is a public model, I would argue needing collective redress, and whether you're online or the question is, where is the public in the story and how will they be invited in to be a part of it as part of the activity? Here's the second model for which I'm going to go back to Google. And it's really, so Google Spain, which is the shorthand for the right to be listed, is totally interesting. One of the things that's interesting is Google Spain puts out something it calls a transparency report. So your right to be dislisted is described by Google Spain through Google, the corporation, through putting out a report with dozens of researchers who are telling you how they make decisions. Why is this relevant here? One, it's a private court system. It is deciding. There are more than 650,000 requests to take down more than 2 million URLs. It has to decide whether your privacy interests or European values of free expression, how do we weigh them? And of course and then it says, I need to tell you that first, more people are asking, and there are a lot from the UK, by the way. And second, I need to give you the reasons why we either take them down or don't take them down. Terrific, except it's both the proliferation of courts. Google as a platform shows you that maybe our courthouses as dissemination bases aren't needed. It's the privatization of courts. And it's the question about how are you going to regulate this alternative system. If Google denies, you can go to your data protection agency. But if Google grants, none of us know or have access to how is Google doing the balance. So it raises the problem of regulation. And we don't have time. There's a clip of a private outsourcing. This is the pristine version, the same way the American Arbitration Association is compared to. There's some new startups that are going to advertise how we can crowdsource all vote and end up with an outcome, and you and I can invest in that too along the way. So we're looking at privatization in a variety of for-profit as well as non-profit size. And here's the conclusion. We're back to the pictograph. And so the pictograph is offering the image of a triangle when we're actually sitting in a square. And the question is, where is the government and the social order and the political will that will pay for the transition to OD, to everything we think the future should bring? How will we get political and social support for government in all of its forms, not just in its dispute resolution forms, if there isn't some way in which the government is advertising itself as a remedial source for something that you want, as compared to saying, please don't come to us. Thanks.
So next up, we have Antoine Garapon, who...
Okay, thank you. Okay. Yes. This is better. Okay. Well, thank you very much. Yesterday we took for granted that algorithms used by programs are all accurate, fair, and indisputable. And I think that it's not really the case. And there is a real problem for the challenge of holding algorithms accountable with the end. Another comment. I think that the basic condition for access to justice is a common access to writing and reading. And this is exactly what disappears with the digital era. There is no longer a common writing because the algorithms, they are a new kind of writing. So we lose the common playing field because algorithms makes all of us illiterate, we cannot read, neither understand what happens. We have to trust algorithms. More precisely, we have to trust engineers we don't know, and even that don't belong to the same legal community. So there is a real challenge of holding those algorithms accountable. For that, there are the first obstacle, invisibility. It's invisibility because we are mostly unaware of that we are already living in an ocean of art. Okay, no, it's very curious. Okay, so we are mostly unaware that we are already living in an ocean of algorithm in our cell phones. In all the programs we saw yesterday, there are plenty of algorithms and extremely sophisticated ones. And they are, as Morozov says, are invisible barbed wires. So it's difficult to complain about alleged wrongs we don't feel. And just a comment, in this country, I think there is no idea, no identification card we have in France. In the US too. But I think that biometrics is far more worrying than attempt on privacy, because perhaps big companies and perhaps foreign countries may have the biometry of all English citizens, but we don't feel biometry because it's not just privacy. So we don't care about it. And again, it's very worrying because of, and that's the same way we are very, very much focused on the Silicon Valley. And we don't enough look east to China. So it's, which is a monster in terms of what they can do with those algorithms. Second problem is opacity, because there is an algorithmic complexity, obviously. It's very hard, actually. It's possible to understand a basic line of an algorithms. It's much more difficult and actually impossible to understand what happens with a deep learning machine, because it's a black box. It's just impossible. We only can assess the outcome, and it is a problem. And another problem, and when we try to control them, they are blocked because of business confidentiality. No, it's not possible. It's secret because of business secret or secret defense in terms of biometrics. It's biometry. It's a lot of, it's the fight against terrorism. It's national safety. So very difficult to because of opacity. Third problem, entrenchment. Entrenchment, because there is no, we think about algorithms in the same terms as we think about words. They are words. It's not, it doesn't work that way. Actually, most of them are collectively created, and they work as a toolbox in which developers combine a lot of algorithms. It's a problem for intellectual property, because it's very hard to know who owns what in this. Well, okay. So and the last problem, you know, it's in French language, when something is too complex, we speak about millefeuille. I don't know if you ever tasted millefeuille, but it's a kind, you know, it's impossible to take out a sheet and to examine this sheet, because it's, well, you have to destroy or to control the whole millefeuille. Okay, and so, and the last problem is legal inaccessibility. That's in terms of, again, we still don't really understand what happens. And that's, it was a matter in our book with Jean-Jacques. We have an idea, we take metaphors as the reasoning of a machine, but a machine doesn't, has no reasoning and no legal reasoning. It's just only calculation, which is extremely different. And then it's very difficult because if we have the English courts or the European court have jurisdiction on a part of the world, business come outside of this jurisdiction. And so we can see that for Google Spain, well, okay, for GDPR, it works for Europe and people willing to do business in Europe, but outside, no effect at all. And the third problem is that judges has to compete with the so-called oracles. We didn't speak yesterday of a very important sector of digital justice, which is a blockchain. There are full justice services offered through blockchain. If you use Kleros, and it's another story. It's very different from internet and from online dispute resolution. They can offer juries. They can gather and panel a jury with people all over the world. They can review documents. They decide. So it's a full trial on the blockchain, and it's, well, again, it's very and what they say judges are outdated. They're old-fashioned. They can't understand. Even the best judges, the more educated justice, the more geek justices cannot understand what happens. So let's use the same system of legitimacy we have in the blockchain or we have in internet in order to settle disputes. There are oracles, which was, by the way, a term of Alan Turing when Turing discovered the computer, let's say, in 1947 here in London, he pronounced a very important conference paper in which he said, pay attention, because we are entering a new era. And in this era, there will be oracles that would protect themselves by complexity. And it will be very difficult to get at what happens in those black boxes. Okay, so solutions. There are solutions. The first of delegate to experts, ethic by design, or how the judiciary and judges and law could take advantage of that. Okay, delegation to independent experts. It's one solution. Appointing, which is not a common law solution, that is much more French habit. So appointing independent mathematicians and computing engineers in charge of controlling the algorithms used by parties, by online dispute resolution, to check, asked by public authorities or asked by parties in a trial. And there is a risk of moving. There are two famous academics say, well, the risk is moving from algocracy, it's a term used by John Danaher, to epistocracy. It means it's the control of algorithms. We are moving to control of it by engineers, but we still do not control engineers. So, and another solution would be to ask them to an oath and to asking to sign special ethical commitments. I don't believe too much in ethics, but I will. Wait. No, in terms of now there are a lot of big companies, big digital companies. They say we are taking commitments on ethical grounds. It's as if there was a syndicate, a union of wolves taking care of sheep. Well, there are the problems, they are not the solutions. So in France today, we have a very dynamic legal tech, and they all have a comité d'éthique, ethical committee. And but this is not law, and I think that none of those solutions can replace judicial review, and it is a problem how to pass from ethical committee of rule of conduct to judicial review of them. Okay, my last point, and that, okay, there can be rigid regulations such as GDPR, but the best for me would be to ask judges just to enforce legal principles such as liability, civil rights, due process of law, and to try to assess in order to see if what, you know, there are a lot of very big and strong announcements from the digital community, and it's a pitfall for us to believe too much in them, and there is room for empirical research, just to assess what happens in the real world, what are the consequences that do happen in the real world. And this is the business of judges. Thank you.
Thank you, Antoine. I think maybe something that we want to pick up, or that strikes me from both Judith's and Antoine's presentation, is the fact that we're sort of focusing on the state justice systems and digitising them and going online. But meanwhile, there is a proliferation of dispute resolution with which the state justice systems are in competition to some extent, and that's something that maybe has come up very clearly from both of your presentations. So thank you very much indeed. I'm going to hand over now to Joshua Rozenberg to give us the media perspective.
It is, yes. Thank you.
Openness and transparency.
It is, and it's very brave of you, Hazel, having invited me yesterday to invite me back again today. But the session is about accountability, open justice, transparency, and accountability. I'm really going to try the technology today, as you will see. I want to start by giving you a very good example of the opposite of open justice, transparency and accountability. You remember yesterday that I was talking about, it's all right, it's meant to do that, don't worry, it's meant to, it's all planned, all part of the great plan. I was talking yesterday about an event that Her Majesty's Courts and Tribunal Service, which is running the online court project, is holding next week. Unbeknownst to me, they put this onto Twitter, and there was a very interesting conversation. Now, some of you may not be familiar with how Twitter works, so you're going to have to look at this quite carefully. Right, zoom in, straighten up, zoom in. There we go. Right. Okay. You start here. You start here with this document here. This is a tweet that went out yesterday morning from Her Majesty's Courts and Tribunal Service. Our previous series of roadshows were held in courts. Our next event is in central London, and we welcome all legal professionals and professional court users to attend. It'll also be live streamed here. Okay, so that was the initial tweet. And this chap called John Hyde, who is a reporter for the Law Society Gazette, says, I applied to attend this, but I've just been told that my ticket has been cancelled. And he puts this on Twitter. And he adds, clearly I'm not a legal professional, but many thousands of legal professionals read the Law Society Gazette who wouldn't be able to attend. Apparently they don't get to be kept informed of developments. And then there's a reply from Ed Owen. Ed Owen is a very good guy. He used to be Jack Straw's special advisor. I know him very well. And he replies, Hi John, ticket hasn't been cancelled. HMCTS has had a lot of interest in the event, so we've been allocating tickets to legal professionals first. If places are left this time next week, then of course you can attend. It's also being live streamed so all can view, and then he adds the hashtag #RockAndHardPlace. Okay, fine, okay, got that, right, okay. Now, you know, of course it hasn't been cancelled. Now, how does Twitter work? Well, of course, John Hyde replies, and he says, I don't know where I got the idea that it was cancelled. Hello, John Hyde. The following order has been cancelled through HMCTS. Order cancelled. Event name, Reform Roadshow, amount, and so on. Order cancelled. And Ed Owen says, sorry, our mistake, we didn't make it clear. We asked people to register so that we could then ensure we gave legal professionals first dibs and those who couldn't make the RCJ event last year, apologies again, ho, ho, ho. So I reply to Ed Owen and I say, oh great, does that mean I can come? And he says, sure you can, we'll let you know next week if there's a space for you. You know, Ed is a very great guy and I respect him a lot, but you know, what are the chances that next week I'll be told, an awful lot of legal professionals want to come and you can't come? It's a classic example of how not to run things. Now, why does HMCTS behave in this way? It acts as if it were a government department, but HMCTS is not a government department. Let me try to zoom in. This is a page from my book, the online book and so on. And what I'm saying there, and this is what I'm writing, is HMCTS is an executive agency of the Ministry of Justice. Under the terms of its service framework document, it operates on the basis of a partnership between the Lord Chancellor and the Lord Chief Justice. The service is responsible for running the courts and tribunals. It has a chief executive and a board headed by an independent chair. The board includes 3 judicial members as well as executive members, non-executive members, and one representative from the Ministry of Justice. It had 16,000 staff last year and so on and so on. So it is not a government department, and its chief executive is not a civil servant in the sense that civil servants defer to ministers in government departments. And yet, my contention is that HMCTS is run as if it were a government department, run as if it were accountable to ministers, and because ministers are petrified of publicity, particularly at the moment, and rather cautious about everything, they are running HMCTS, or at least HMCTS thinks that it is being run in a way that means that they have to be terribly frightened of the public and the press. And that, in my view, is utterly wrong and not the best way to meet the targets of open justice, transparency and accountability. Now, contrast that with the judges. The judges understand very well that they are accountable to the public. Let me give you an example. At the moment, it is lawful to broadcast on television, live if appropriate, proceedings from the Court of Appeal, criminal and civil, in England and Wales. You know that there was a great concern 18 months ago over the Article 50 Brexit Miller case, and the Daily Mail came up with a headline, Enemies of the People, and it caused a very great deal of damage to the judiciary, recruitment, confidence, morale, and everything else. There was no such coverage when the case went to the Supreme Court, and one of the possible reasons for that was that the proceedings in the Supreme Court were televised, they were available to broadcasters, people could see that the case was being done properly and sensibly and so on. It's not the only reason, the political climate had changed, but nevertheless, televising proceedings is perceived by some judges to have had quite a considerable effect on calming things down and indicating to the public that judges were not enemies of the people. Unfortunately, the original hearing, the initial hearing, was in the Divisional Court, part of the High Court, and under the rules that currently exist, it was not accessible to the broadcasters. This, despite the fact that it was heard by the Lord Chief Justice, the Master of the Rolls, and the chap they brought in to write the judgment, a Lord Justice of Appeal, they normally sit in the Court of Appeal and they're perfectly used to being televised. There were no witnesses. It was entirely the sort of case that could have been televised, but the laws don't allow that. In my view, that's a shame. It should be changed. I think that message has got through to the judges, and that is why the Lord Chief Justice told us a couple of weeks ago that he is taking steps to live stream civil appeals in the Court of Appeal as soon as he can get the thing sorted out. He's bought the equipment. I'm sure there's a lot of work that needs to be done, but in due course the intention is that 2 courts in the Court of Appeal Civil Division will be live streamed. Why is that a difference? Because although it is available to broadcasters, the proceedings of the Court of Appeal don't often make it on television. They are not terribly easy to get into a soundbite. Lawyers and perhaps even judges don't necessarily speak in short, brief quotable sentences, and it doesn't get on television in any great detail very much. Live streaming would mean that it would be available on the internet and it would get on. And that's the message that has been understood by the judges, and they are very keen to publicise what they do, because they think that if they are seen more by the public will appreciate what they do, respect what they do, support what they do. They understand the importance of publicity. And the questions now for the online court are, what are they going to do? Susan Ackland-Hood told you very accurately yesterday of the first hearing of a video court. I was there. It was a tax appeal. The taxpayer was at home. Her Majesty's Revenue and Customs were in Belfast. As Susan told you, the Taxpayers Skype service worked perfectly. The service from Belfast was very patchy. It was very difficult, but nevertheless, the judge who was in court watching these two faces on a screen was able to cope and was able to hear the case to everyone's satisfaction, and we sat at the back and watched. That was fine. That works in principle, very good. The problem, of course, arises when you have what is, I think, called a fully, it was fully video, it might be now called fully virtual hearing, or perhaps it's the other way around. Fully virtual is now going to be called fully video hearing. Doesn't make a lot of sense, but you know what it means. It means that nobody is in a physical courtroom. The judge is in front of a screen, and so are the parties. Where do the media go? The suggestion was that there would be some sort of video booth that we, the media, and perhaps any interested member of the public could attend. Quite how this is going to be managed for all the possible online hearings is something that we wait to hear from HMCTS. It's tricky for all sorts of reasons. The whole point of these video booths that we are going to be able to go to, we're told, is that if you put this on the internet, then people can record it, and that would be improper, and they're not allowed to, and so on. So the courts need some sort of control over it. And yet, at the same time, it has to be open and accessible, and the judges have made that entirely clear, and that is how it should be. In the end, though, you have the problem that they are creating a system which is meeting this important principle of open justice, transparency and accountability, and is hardly likely to be taken advantage of by the media, because behind all of this is the collapse, the slow and steady decline of the mainstream media, the absence of reporters in court, the collapse of the business models of the newspapers, and all the problems of covering serious events in serious outlets. And that is a problem. It's contrasted with the rise of social media, which is why the judges are right to be talking about live streaming their proceedings rather than trying to get them across to the public in any other way. It's a major problem. It requires a great deal of thought. I certainly don't have the answers. I'm not going to stand here and say everything has to be broadcast, everything has to be made accessible, everything has to be made more accessible than it is now, in the sense that it just won't be used. On the other hand, the principle is absolutely sound, that if we, the media, or you, the public, want to go along to public court hearings, that must be possible. It must be easy, it must be straightforward, we must be able to find out what goes on. It's actually possible for an online court to be more public in the sense that its judgments are more available. Shannon's judgments are published on her website, and we can see them. They're very easily accessible, and the growth in social media and the internet, of course, has made it much, much easier to get hold of huge amounts of information, such as judgments and everything else. But we do need some thought as to how to make this accessible, and when, to take up Lady Hale's points last night, family proceedings should not be accessible to the press and public. My general principle is if you are going to exclude the public, then you try to keep the press in. If you are going to limit reporting, then you at least have the press there. You try to anonymise it rather than to prevent anything being published at all. It's something that's being considered in Northern Ireland, where they're having a review following a rape case, which led to a great deal of concern. These are all very big problems. We have no time, I have no time to actually answer them today, or even resolve them, or even talk about them, but I just thought I'd let you know these are some of the problems. Thank you.
I need 2 microphones.
Thank you, Joshua, for making very clear some of the key problems. And one of the things I hadn't thought about was in the process of worrying about online proceedings to which we don't have access, and then the absence of any kinds of hearings to which we don't have access or might not have access. At the same time, you actually have a weakness in the media and their ability, even if it were possible, the weakness in the media's ability actually to provide the kind of accountability that we're thinking about. So that's another point for discussion, I hope. Moving on now to Karen Broadhurst, who's going to be talking about the work that she's doing. She's being wired up. The work that she's doing on the Family Justice Observatory, which we heard a little bit about last night. Those of you who were at Brenda Hale's lecture last night would have heard something about that.
Okay, thanks. So we've had some incredibly interesting theoretical papers, so I'm going to bring you down to earth a little bit and talk about a new Family Justice Observatory for England and Wales that the Foundation is launching. And I think Tim is in the audience here, who's the head of the Foundation, CEO. So this is about family justice, not civil cases that we've predominantly heard about. And just to pick up on Joshua's point, obviously the family courts are closed. So what I'm going to focus on is the role of the observatory in improving access to data as a way of improving transparency. So I'm going to try to start by introducing the observatory, then pull together the themes of data and transparency and how we can use data to help us think about transparency in a different way. That's not to in any way undermine Joshua's points about serious media reporting of family cases, but it is an alternative perspective. Okay, so just to start, Lady Hale introduced the observatory, so I'm going to keep this brief, but obviously the Foundation is known for its role in family justice research, has been for a long time, making a major difference. So as a small funder, punching well above its weight, making a major difference to our understanding of the family justice system. And it's building on that success. It's in a very good place now to develop a really good programme of concerted effort around the observatory and to try to tackle and improve the supply and application of empirical evidence. So the overarching aim of the new observatory is it starts from a position that social science evidence, other forms of non-legal knowledge as yet, do not significantly impact on the family justice system. I'm sure that's something many of you in the audience will agree with. This is a particular issue, I think, for family justice because our courts are closed, largely closed, and the family justice system makes highly consequential decisions for families. So decisions about whether siblings should be placed together, whether children should be permanently removed from their parents. These are all vital decisions that need to be informed by empirical evidence alongside other forms of knowledge. So this isn't about replacing professional knowledge, but it is about saying, can social science evidence come alongside that evidence? And can we find a stronger place for social science evidence within the family courts, both in terms of system intelligence, but also improving decision making? So just to come to the themes of this symposium, limited intelligence about the family justice system invites questions about effectiveness, but also fairness. And I think those questions are really coming to the fore in family justice, a bit like they are in civil because of unprecedented cuts to legal aid and private law cases in particular being now a major issue for anybody who's looking for representation. I just want to take you to the scoping study that we conducted prior to the Foundation taking decision to launch the observatory. So what did our stakeholders, so we did a national consultation, what did our stakeholders say to us about the family justice, what they thought currently about family justice and the place of evidence within it? So it'll be no surprise to you that many alluded to a black box of family justice, and many of you will have heard reference to our secret family courts. When we kind of unpack their statements that they made to us in consultation, we could say they were about effectiveness, but they were also very much about fairness, and they're about service accountability. So stakeholders were very concerned whether the best decisions are being made for children, whether practice is fair or consistent, particularly across courts, but also what is the impact of reform. And that last point, I think, was something that was really strongly in the minds of many of those who spoke to us during the consultation. Just a little quote at the end. So, from organisations representing parties to cases, through to lawyer organisations, through to social workers, judges, everyone was concerned that their anecdotes, if you like, couldn't currently be substantiated by sufficient intelligence about the system. So a little anecdote there, little reference to an anecdote there from the Association of Lawyers for Children. We've got Julie and Martha in the audience here who did a lovely submission for us to our call for evidence. And there was real concern about fairness, both pre-court and post-court. So, cases that come into the court, into the family justice system, are highly dependent on the input of preventative services beforehand. And currently there are many questions that we can't answer about children's pathways into the court or beyond. Okay, so turning to the issue of transparency, we would say that data and the digital revolution transformation is a real opportunity. So for those of us who work in interdisciplinary research teams with computing experts and statisticians, we are extremely excited and pleased that we're seeing digitisation of process. So here I'm not talking about the kind of future, the cyber courts of the future. I'm talking more about where we are now, which is we're increasingly seeing e-filing, e-record keeping and e-management, and all this is incredibly valuable data for us. In order for that data to be effective, we need really good collaboration between stakeholders, academics, policy, practice and data science. And this did come up yesterday when Susan was talking about the development of their online systems. I just want to stress that point is that we can look forward to even richer digital futures for empirical work if we get that right. So we need to design in from the start methods of capturing data. In relation to family cases, independent statistical analysis, so the kind of big picture statistics, provides a really strong counterbalance to a focus on the individual case or the anecdote. And I think that we've spent an awful long time thinking about how we can let the media into cases, how we can sponsor responsible reporting, but all of that still is based at the case level. So a counter to that is to think about the big picture and think about system level information, which is highly persuasive, I think, in terms of giving you actually a representative picture of what's going on in the courts. So independent statistical analysis can help us build public trust and confidence, which we know from our stakeholders are still wanting in this space. Okay, so I think I've said that first point, that poor design, I think it's a really important point to emphasise, poor design during the process of digital transformation will rob us of opportunities and will waste public money. So we do need to work much more closely alongside. So we need academics, we need policymakers, practitioners, all those people who are involved in system design to come together. There's no place for silos here. I think the other point that could undermine, and these two points are for the research community and for funders, I think that what can also undermine us taking advantage of the digital opportunities are insufficient quantitative and computational capability amongst the socio-legal research community, but also among analysts within government. So I think within government, the issue really here, and I'm looking at Alexi at the back, is about capacity and the fact that we've seen our government departments stripped back, and so we have very limited capacity within governments to actually use this rich data that they have at their fingertips. Okay, so we need to now be thinking about the challenge of growing computational quantitative expertise alongside traditional socio-legal research, and so that we can meet the current challenges but also those that lie over the horizon. So what's the observatory going to do? Okay, so I've got about 2 or 3, I know it's 11:15, so about 2 or 3 major points to make, and then I'm going to conclude. Obviously, an immediate role for the observatory, we would say, is to release some of these digital resources. And obviously the ADRN, those of you who know about the Administrative Data Research Network, have had a go at that, so we can learn from that experience. But But as we await new cyber futures, as we await the image of the cyber judge in the family court, which probably never will happen if we listen to Ernest, but we might see certainly some technological innovation around the edges, I'm sure. But as we wait for that, we should try to actually release those records we now have at our fingertips. So there are millions of electronic records waiting to be used that can be linked, that can be joined up to tell us that pre-court, post-court holistic picture. So the observatory is going to, obviously the fine detail of this is under negotiation, but the observatory wishes to try to take the best of our kind of globally leading safe houses and use that facility to deposit some of our family court data and to demonstrate the use of that data through using single data sets and linked data sets, but also to support others. So this is a capability building project. So the observatory is very much an enabling and collaborative enterprise and wishes to basically encourage others to come and use this platform that we're going to create. What I would say is, and I was talking to Alexia again at the MOJ about this, saying that I live up near the Lake District and I was invited to co-lead a leadership forum over there about data, so kind of across all the services and sectors. And I was asking them, had they heard about the MOJ data platform and what the MOJ was doing? And of course everybody said no. So I think the thing is, we know that online mobilisation isn't really effective. So the other arm of the observatory has to be to reach out to people on the front line, mobilise research and help people to interpret and apply that research. So when you see a wavy line of graphs with variation, at what point does variation actually matter? Another role for the FJO, for the observatory, in relation to digital transformation is obviously to scan, experiment, horizon scan and see what's lying over the horizon, because obviously we've heard today about algorithms permeating everywhere, the ocean of them lying beneath our infrastructure, and we need to kind of keep pace with change. So the observatory will also horizon scan and seek to do that. This is a big and exciting project. I think the foundation is brave to take it on, and I'm probably brave to do the initial 12-month setup as well. But hopefully, by better using our electronic population level full service data, we have a window into how the system sorts, codes, classifies, and the outcomes for families. Okay, thank you.
Thank you. Thanks so much, Karen. I think that what we've heard, it had 4 fantastic presentations. And what I hear from that is that there are opportunities, threats and challenges in the digital revolution. I think on the one hand we've got the potential, we've just heard about the potential for greater transparency, but we've also got the exclusion of the public and the media from the processes. And I've got a question about whether system level information, which I think could be fantastically interesting and useful for research, is that as good as, better than, or a substitute for individual case scrutiny, which we can have at the moment. So these are just some things that strike me. I'm sure that you have lots of questions. We've got about 15 minutes for questions, so if there are any hands here, do I see? I see there. Okay, I can see lots. 1, 2, 3, 4. Can you keep your questions relatively brief, please? Okay, David, do you want to go first? You shut up first.
Yeah, okay, great, thanks. So a couple questions for Judith, which I'll make quick. Your first slide was kind of against the DOJ's boilerplate, kind of warning people away from justice. What's wrong with private ordering? And the second question is kind of about one of the last things we said about the very low usage rate of AT&T's ADR. People use dispute resolution with AT&T and every other phone carrier every day. They call and complain. And so if you counted that, there are probably thousands. And so we've got various alternatives. Call and complain, ask to talk to the manager, switch phone carriers. So is this a bigger problem when you do have these other alternatives?
So private ordering that imagines consensual interactions through contract is terrific. I don't have private ordering with any of the wireless services. I have to buy the bundle. And so it's not that I'm ordering anything, I'm actually being ordered. So the first concern is, could we generate systems of forms of private ordering? Yes. It's a mistake to think about this as private in the sense that it is the government regulation of this that is enforcing this market. So imagine in a world of private where you and I go off, and if we can't come to an accord and we then go and try to enlist the public system could say, come on in. Or the public system could say, I'm sorry, you're in private ordering. We can't speak to you because you're in the middle of negotiating. What we saw was the United States Supreme Court taking an antique statute and turning it into a public mandate over that displaces state contract law, which is another form of majoritarianly based democratic value engaged principles, to insist that this statute displaces federal and state contract regulations. So on the private ordering, I'm happy to have some. I don't have it in this place. The next question is, how do we think about metrics of use? And what do we know when people either come to court or don't come to court? And it's actually a debate that is no way unique to arbitration, mandated alternative dispute resolution, mandated a whole bunch of things. So that's, again, when will the government make rules about how we talk to each other or don't talk to each other, which of course is the backbone of contract law. And in this instance, the inquiries trying to understand from AT&T. So AT&T actually also advertises that if you do win against it in arbitration, it will give you a big bonus of fees and the like. So of course I asked the lawyer, tell me how often you do it, to which the answer, apropos my colleagues here, was we won't tell you. And so in this world of information disgorgement, I'd love to know more about how many people call AT&T and complain. When the Federal Trade Commission and the Attorney General sued all the 4 wireless carriers, they all said, the complaint said, people are alleging what are called phantom charges. It's $9.99 for something I didn't buy that comes on my bill. And for me, at least, I find those bills very hard to read. But other people may have better literacies around them. So in assuming, one version is you call up and complain, and they give you back some money. The allegations in the filed complaints was that if you called up and complained, you might have gotten 2 months back on the 9 months that they charged you. So in a world in which we have full disgorgement of information, I might have more cheer about the private accommodation systems. I know eBay and some other providers say everybody's happy, but I can't read the records the same way I can't read Google's. I think it's a real problem because I use Google because we value the privacy of the individuals. If a public court system were doing it, how could we get, this goes to the family law example, how could we get good underlying understandings of rights, obligations, fairness, distribution, private ordering, and respect the needs of the individual? That's the communal challenge that we're facing, individual and aggregate. And it is the blockades that we're looking at. And the public systems we're hearing are the cheerful end of the story. The only reason I know anything about AT&T is because California has regulation, and the upright American Arbitration Association is a good complier. California has at least 20, more than 25 providers of consumer regulation, consumer arbitration, and more than half of them don't even file the data that's required.
I'm going to take another question now. Is it Jim then, and then over here, and then Richard? Okay.
It's for Antoine. It's Jim Greiner from Harvard Law School, and I'm looking down just because I took some notes. Just a challenge to the overall thrust of your presentation. Are you comparing an idealized version of human decision-making, a human-run judicial system, to the actuality of an algorithmic run judicial system? So I got 3 of your 4 primary complaints about an algorithmic: opacity, entrenchment, and legal inaccessibility. Just to run through, I couldn't get the 4th one because my fingers weren't fast enough. But human decision making, to give you an idea of what I mean by, I think what we should be doing is comparing as opposed to criticizing, the flaws of one system. human decision-making is about the most opaque process, I think, decision-making process we've ever come up with. Entrenchment, it's impossible to dislodge human decision-making from virtually any form of society, major involvement. When we do, we might find out that we like it a lot. For instance, we might find out that there are fewer accidents if computers drove cars. And legal inaccessibility, I mean, in fact, the fact that we're having this conference about how incredibly inaccessible a human-run justice system is suggests that there might be some issues. And the idea that we need to make sure that we have judicial review at the end of a human decision or an algorithmic decision-making process scares the bleep out of me, because I know how bad human decision-making is and how hard it is to keep a human's fingers off of a red button to outlet the process. And so, again, I've overstated the case deliberately. I think that, the idea is balanced, but the point is maybe we should be comparing the actuality of one system to the actuality of another one.
Go ahead.
Well, it's a very long answer that I will make it short. I think the problem with your approach is what happens in terms of legal theory. Through digital algorithms, there is the creation of a new natural law. The reference of law is no longer human decisions, is the reference of exactly what was mentioned. I think it was by Joshua yesterday about the quotation of Oliver Wendell Holmes. The law is the anticipation of judges will decide. So this anticipation is no longer performed by lawyers, it's performed by machines. So the reference of legal, as judges are human, and there are a lot of biases in their legal reasoning, the reference of law is no longer human. It's just an abstract machine produced by algorithms. And this is what we are going to, because of, and there is in France at least some articles of people saying, we will get a better justice through algorithms because there is no bias. It's absolutely scientific, and it will be much better than the justice given by human beings. So it's a long debate, but I think that yes, obviously judges are biased, and obviously judges make mistakes, misunderstandings, they don't fully catch what's happening. But what's the alternative?
Okay, so what you're saying is it's just a completely different.
Yes. Yes.
In fact, it's not. In a way, it's not comparable. You're just saying this is what we've got now. This is what we will have then. But understanding the decision-making process is going to be no easier. I don't think. Another question. Was there another question here? Oh, Richard had one, and then Garapon.
It's kind of coming in on the debate between Jim and Antoine. Because there is this risk of the withering of rules if everything is decided just on the basis of data. We simply become categories and there are no principles by which decisions are justified. There's an interesting parallel debate in relation to the regulation of innovation, which for me suggests there's quite a lot of ways of trying to work out how or explain or govern how the black boxes are working. You can simulate cases and see how they work through the systems, technical systems. You can change data in those cases, or you can change a data point on a person. So you might say, well, I've gone through the algorithm as a self-employed person, how does it deal with me if I'm employed, as a way of explaining to people how the decisions are working. Those kinds of things might be possible. But also the other thing that for me emerges from the literature is about the governance of the system. Who understands how the system's working, who is accountable for how the system's working. That might be the judges who have to look back at the online court, for instance, and look at how the triage is done, and how the mediation is done, and the negotiation is done. But that might mean they look at it more in a way that Karen talks about, in terms of having a suite of data rather than reviewing a case and applying a set of rules to a case. So that's a point.
Is that a point? Yeah, that is a point. My question. I don't know whether Shannon wants to say anything.
I have a lot to say. I want to get my time up there. So.
Oh, okay, so get it later.
You've opened the door though. So
okay, go ahead.
To Joshua's point about the open court principle, that's something that we've really grappled with, and our statute provides that if we have oral hearings, they need to be open to the public, but of course we don't have them in person. And so we've looked at that, and I've asked myself a lot about this, and I think where I've come to is that the whole point behind the open court principle is so that you can have a view to the decision-making process, so that it's not arbitrary. And I wonder in an online context if there are good ways of doing that that don't necessarily mean you live stream every oral hearing about a small claims case. Maybe that means, as we have, highly robust searchable database decisions written in plain language in real time the moment they're issued. Maybe that means you have access to all the evidence and records and submissions. Maybe that means that you can request an audio or video copy of the hearing. But I don't know if that, I worry about us making false equivalencies too, because yes, we have pictures of open courtrooms, but how many people take time off work and go down to those courtrooms and observe justice happening in the 1% of cases that actually make it to trial? I don't think that the open court principle has been very well served under our current system either, which is not to relieve online courts from its obligation to be transparent, but I just wonder what the open court principle really means for people today in this world. And I think it could maybe be achieved in different means.
I think Judith
your goal, of, at least as described, is to abort open hearing.
No, that's not the goal.
The way the systems and the 1, 2s, and 3s are, a whole bunch of them are to say, please do something that gets you outside the system when there would be an exchange with a judicial officer. Those are the steps, at least as...
And now that you've opened that door to
Sure.
your point, I think that it is wrong to characterize alternative dispute resolution as a way of saying, get out of the courts, go away. In our world, and the way I envision the justice system of the future, is to say, come on in, and we will give you tools to solve your problem that don't just mean a judge decides, but that doesn't mean it's operating outside the justice system. In that sense, we should get rid of the alternative. It is dispute resolution, and dispute resolution should be conceived of more broadly than just a judge saying yes or no.
Okay, I've got quite a few people who want to come in, but I want to bring in Ernest at the moment. I don't know what point you're going to make, but one of the points that I would like one of the judges to address at some point is this question about the withering of the law. Where is the law in all of this? Okay, Ernest.
I have difficulty making that point. That is one of the themes that we only had a line about yesterday. It's hugely important. I don't live in a world where I accept that the privatization of the evaluation of rights is something that I would commit to a private sector organisation so that they determine what my rights are by changing the way in which they deal with the public aspect of the law. That's a simple proposition, and I don't change my view about that. What Shannon is saying, I think, is hugely important. There is, in the view of England and Wales, a distinction to be drawn between adjudications or administrative decision-making, which is not covered by Article 6. Article 6 is not engaged, and in those circumstances where Article 8 is taking priority, we frequently do not publish the reasons or the judgments that are in play. Family justice has got Article 6 in play, but we keep that private. Some of my administrative justice tribunals remain private for all purposes. You do not get in to see them, you do not get to see the result. That's why what I would seek to do is to make where Article 6 is engaged, which is the vast majority. You have nothing less than you have at the moment. So every judgment, every reason, online or through video, is published. Furthermore, the data that belongs to that should be mineable by the academic community. That's where Karen comes in. Looking at it with my Nuffield hat on, there was a huge basis upon which you needed to have an observatory to bring together the data. Then you could start to look at how to analyse it and get it out there. Otherwise, the judiciary's very proper confidentiality of children's information becomes something that hides the public from the public gaze. That's not what we're about. So Joshua was absolutely right. The judiciary take a different line from what one perceives ministers take here, because we don't know what line ministers take. There is no public discussion from the Lord Chancellor or one of the ministers, and hasn't been at almost any stage of this process. I think scrutiny is important. I think public scrutiny is important. I think media scrutiny on behalf of the public is important. The idea that HMCTS, that is answerable to me, Ian Burnett and the Lord Chancellor, can seek to withdraw invitations to the media, it is frankly appalling. And yet the partnership is one that I'm supposed to be running. Now, I don't know it unless I come to a conference like this. But one of the things I didn't say yesterday, and it's perhaps important to say, is that the 2005 constitutional settlement has always been work in process. The framework agreement was designed to last for 5 years, or now 10 years plus, into that framework agreement. And it is inevitably the case that if one partner is a minister, you will be politically risk averse. If the other partner is the judiciary, I have only one thing I can do, and that is to fire the exocet and abolish HMCTS by going to Parliament. It's the only power I have got. I appear at the bar in front of the House of Lords and say, hello, I'm here, I'm firing the exocet, that's it. What happens then? The minister and the minister alone controls justice. That's why the Chief and I don't do it, because the cooperative arrangements that we have are such that we have far greater influence by not firing the exocet. But at the end of the day, they shouldn't be doing to Joshua and his colleagues what they're doing. That isn't right.
Well, it's good that you came here and heard that. Thank you for that. I know that you've been waiting to speak, but actually I'm worried about getting people out for coffee and then coming back again. So could I ask you to raise any more questions that you've got with the panel while they're trying to drink their coffee, and me time to thank them very much for fantastic.